If land can be owned, then it might seem obvious that if you own some land and build a house on it, then that house is your property. And if you plant a tree on your land, that tree is yours too. But when that tree drops a leaf and the leaf falls to the ground, do you own the falling leaf? When you build a chimney in the air on top of your house, you own the chimney. So do you also own the smoke coming out? And what about the plane flying overhead? Is that on your property? Who owns the sky? It's a fascinating question that has entertained lawyers and judges for hundreds of years. In this video, we're going to focus mostly on American law. But our story starts all the way back in old-timey Britain in the 16th and 17th centuries, when it was deemed illegal for houses' roofs to overhang your neighbour's property. These rulings were based on this old Roman maxim, known as ad coelum for short. What ad coelum means is that whoever owns the soil owns upwards to heaven and down to hell. In other words, you owned a cone from the centre of the earth through the surface at the boundaries of your property and limitless into the universe. This was never a Roman law, but did form the basis of English and American common law after successive rulings throughout the following centuries. A common law is a law that is not legislated by governments or politicians, but that is based on precedent and case law from successive rulings of judges. So because land rights extended ad coelum, trees, houses and walls were all capable of aerial trespass. But of course things became more complicated with the advent of aircraft. Between the late 1700s and early 1900s, at first hot air balloons, then blimps and zeppelins, and of course planes hit the scene. In the early days of flight, aviators basically had the skies to themselves. There was no regulation, and even though the maxim of ad coelum was still around, landowners were more excited by the idea of human flight than they were worried about trespass, even though it probably technically was a trespass for an aviator to fly over their neighbour's property, thanks to ad coelum. But that didn't stop lawyers worrying, and because this was still before World War I, it actually wasn't perfectly clear whether even countries themselves had sovereignty over their own airspace. After all, similar international disputes regarding sovereignty over the sea were predominantly leaning towards the sea being a place free for navigation, although the UN Convention on the Law of the Sea was still decades away. The sea and the sky aren't really the same though. For starters, gravity exists, so any items dropped even from a great height could cause damage or intrusion on the ground. While there were those that argued airspace could never be possessed, with the start of World War I and the threat that enemy aircraft posed, countries seized full control and regulation over their own airspace as a matter of national security and public expectation rather than law. This was enshrined after the war in the Convention relating to the regulation of aerial navigation, which confirmed every power's complete and exclusive sovereignty over the airspace above its territory. The US never actually ratified this international agreement, but did ratify its superseding agreement, the 1944 Chicago Convention. It also made its own laws, and today, government sovereignty over all US airspace is enshrined in Title 49 of the US Code. So, back to the 1920s, it was accepted that countries controlled their own airspace. But where did that leave landowners? If their rights extended ad coelum, could they charge for airplanes flying over their properties? And could they otherwise sue for trespass? It would be more sensible just to make laws allowing planes to fly over private land. And that's exactly what Germany, France, Switzerland and the UK did. And in the US, by the 1920s, it was generally agreed that allowing overflight was a good idea. But because of a pesky document called the Constitution, the conundrum was how to enact this. The Constitution protects the rights to property in the 5th and 14th Amendments, so it was feared that allowing planes to fly over private property could be contested as an unconstitutional deprivation of property and liberty. This led to a sluggish rate of legal change in the US, particularly compared to the lightning pace of technological development of aircraft. With each passing year, aircraft were becoming more advanced and more numerous, and as a result, air commerce was booming. So the United States needed to do something, and between 1921 and 1922, the Uniform State Law on Aeronautics was drafted. This law permitted aircraft to fly over private land as long as they did not fly too low or interfere with the landowner's use of their property. The problem with this law was in the name. This was a state law and was non-uniformly adopted by just over 20 states within the next 10 years. What it did do was deftly skirt the issue of constitutionality and ad coelum by asserting that landowners did own their airspace, just with the proviso that aircraft also had the right to fly through it. This was similar to the way that rivers were treated under the law. They flowed through private land, but the right of passage along them was preserved. So with about half the states adopting this legislation, there was still no federal uniformity within the US, until in 1926, when the Air Commerce Act made matters even more uncertain. The Constitution protects Congress's right to regulate interstate commerce, and it's on these grounds that the Air Commerce Act was enacted. This upheld the freedom of navigation for planes over private property through navigable airspace, that is, above the minimum safe flying altitude, but only for interstate and international flights. The same section of the Constitution was already allowing for the government to regulate intrastate commerce in the form of railroads, shipping, and radio. And indeed, the Act did include regulations that were not specific to interstate air commerce, such as registration of pilots, but on the question of land rights and trespass, only the rights of interstate and international travel were considered. That's at least until 1938, when at last the Civil Aeronautics Act upgraded the Air Commerce Act by extending the right of transit through navigable airspace to all flights, not just interstate and international ones. So, aircraft are allowed to fly over your land at a high altitude, but what about closer to the ground? There are several really interesting cases from around this time, but for the sake of the length of this video, we will just talk about the big seminal moment in US airspace case law history, United States versus Causby. In 1945, a chicken farmer and their family sued the US government after a military airport next to their farm started flying planes at such a low altitude over their property that their grandchild was kept up at night. They lived in fear that a plane would crash into their house, and that their chickens became so startled at the sound of an airplane they burst themselves open against the side of their coop. Normally, the US government can't be sued unless Congress says it can, but Causby alleged the government was in violation of the Constitution, so they could sue for takings. They alleged that by flying planes so low overhead, the government had effectively taken their property from them by taking away their private enjoyment of it and effectively taking away their chicken farming business, so they sued for just compensation. The claim was heard initially in the lower courts, and finally in the Supreme Court in 1946. The Supreme Court found that the landowner owns at least as much of the airspace above the ground as he can occupy or use in connection with the land, and that landowners must have exclusive control of the immediate reaches of the enveloping atmosphere above their land. This basically asserted that landowners do own the airspace immediately above their property, so it could be trespass to fly over someone else's land at such a low altitude that it prevents their enjoyment of their private property. In the end, the Supreme Court ruled that the government had taken the chicken farmer's property and ordered they be compensated. So, how much of the sky do you own? Well, at first, under the ad coelum inspired common law, landowners owned all the way up to the infinite universe. Since the non-uniform state law on aeronautics and Air Commerce and Civil Aeronautics Acts, planes flying at altitude over private land are not trespassing. And since then, the Supreme Court ruled that the landowner only owns the immediate reaches above their property. You definitely don't own all the way up to space, not even close, but there is no exact boundary between your airspace and public airspace. And in the US, even your airspace is still regulated by the government in the form of the Federal Aviation Administration. As the FAA puts it, there is no such thing as unregulated airspace. This issue of sovereignty above us is far from solved. Space travel has raised difficult questions about the upper boundary of state sovereignty in the sky, And closer to the ground, the proliferation of drones will no doubt increase the discussion around aerial trespass. Let me know what you think about sovereignty above the ground, in the sky, and in space. Should there be boundaries, and where should they be? And if you really want to impress your friends with knowledge of ancient common law, you can get one of these Ad Coelum t-shirts which I designed. Links below. Thanks for watching, and see you next time.